important, if not the most important case in the context of EU law and EU development. So, well, today, Hussein and me are really attempting to show you why this is so. And in the process, we will really examine the crux of the case and its consequences. But before we can really appreciate the significance of NGAN, we have to first understand the issues that arose out of it. And it's actually quite funny because the case itself is actually not that awe-inspiring in any sense. In fact, it's actually quite boring. It's actually about custom duty tax. And it's so amazing how something so plain actually led to such a significant development. And basically what happened was, a company imported into the Netherlands a substance that was secure, which they believed at the time was subject to a custom duty tax of 3%. However, what they did not know, and this is where the contention rose, was that 2 years prior to their import, the Benelux states, of which obviously Netherlands is a member of, signed an accord, a treaty in a sense, which reclassified a lot of certain items into different tariff ordinances, which effectively actually reclassified the substance in question into another tariff ordinance, which was subject to a tax of 8%. Now here's the problem. Article 12 of the European Economic Community Treaty states that member states have to refrain from introducing any new custom duties in terms of imports and exports between themselves, but at the same time also abstain from increasing already existing custom duties tax. So in this sense, and obviously and expectedly, the company objected basically amongst the lines that this is illegal, this contravenes the custom freeze introduced by Article 12. Now, as sound as their argument was, it was initially rejected, and they appealed to the Dutch Tariff Commission, which was the final tribunal on the matter. Interestingly, the Commission took the view that what we're actually dealing with here is a matter of interpretation, namely interpretation of an EEC treaty, and hence halted the proceedings, and then submitted 2 questions for preliminary ruling to the European Court of Justice. Essentially asked firstly, in the most basic sense, did the increase contravene Article 12? Was it illegal? But the second question is quite interesting. It asked whether Article 12, whether such a treaty provision had direct applicability. And by that, they're really asking whether nationals of member states could actually lay claims of right of these obligations for which national courts must protect. Well, this question is really interesting. But before I look at that, there are actually, if you really look at it, a lot of issues surrounding the case itself and the questions. Basically, all these issues are actually, in fact, identified in the observations made by the member states themselves. Firstly, are we really dealing with interpretation here? Or interpretation as we understand it in the conventional sense? Or as they understood it in the traditional sense? Because it seems to me what we're dealing with here is more an application or this application of Dutch tariff tax law. So are we actually dealing with interpretation, or is this the conceived jurisdiction of the ECJ under Article 177? Well, they believe it wasn't. But secondly, it seems like what we're dealing with here is actually a matter of Dutch constitutional law. So again, it's really a question of which treaty applied to the Benelux Court or the EEC treaty, and whether legislative measures have been put in place to properly reflect these obligations. Matters of a constitutional context, of which, again, the question is asked, is it within the ECJ's jurisdiction? Because, according to them back then, states are autonomous. Are they really fit to rule on these matters? Furthermore, most importantly, what they understood then, and what a lot of us still think today, is that the EEC treaty is just that, it is an international treaty. In the sense that, from what they understood back then, international treaties do not create direct burdens and obligations upon states without legislative implementation, of which nationals of member states could rely on by claims of right. In relation to that, also the idea that asserted treaty violations should only be litigated upon the complaint of member states, because what we have here is an international organization as they understood it, not like some sort of international appeal process. So those are the issues then. Now, and altogether, in summary, what we can infer from these views is that the member states back then engrossingly viewed the nature, the role, the scope of the EEC, the ECJ, and its treaties radically contrastingly different from how we feel it today. And it's amazing because it seems as if, and I drew this by the way, and it seems as if that the ECJ especially and the treaty themselves are actually undermined because, this tends to be this view that the EEC treaty is just a conventional treaty with a really narrow scope of application. The ECJ seems to be suggested to be out of its jurisdiction in a lot of matters in the observations, as we can see. Altogether, it's quite amazing. And amazingly, the Belgians actually highlighted in their observation that because we're dealing with constitutional matters, it is probably exclusively outside the remit of the ECJ. Now, together, what we can really see is that this supranational idea of the nature of the EU as we know it today seems almost materially non-existent back then. Now, I know it sounds like a really absolute claim, so I'm going to be safer and I'm going to say perhaps at least it's really materially downplayed, and what is instead emphasized seems to be this intergovernmental autonomy by the claims themselves. So, and it's quite amazing because surprisingly, the ECJ eventually ruled that the increase was contravening Article 12. But in answering their questions, it held that, and in this statement it expounded, that the EEC constituted a new legal order of international law for which member states have limited their sovereign rights in certain limited fields, for which subjects comprise not only of member states, but also individuals, nationals of member states. And this statement is really, really profound, because it really challenged all the views I just highlighted, which was, at the time, pre-existing. And it's profound in the sense that it really reshaped and remolded our conception of what the EU is, the very fabric of the EU. For my part of my own analysis, I say that the court's voice and actions really led to, for the very first time, gave us a conceptual framework of the modern EU as we know it today. That it shifted one from viewing the EU as just a mere international organization, something that's not taken as seriously, to, for the very first time, this overarching, unified legal order that constituted a new way of being a new order. And it's significant, especially in the sense that it talks about the limitation of state sovereignty, because when it talks about this, limitation of sovereign rights, it's really darkly implying that, as in contrast to view of intergovernmental autonomy, states actually lose autonomy within this organization. And itself also suggestively hints at the supremacy of EC and EC law. And it's actually not surprising, actually. As part of natural development, a year later from now, the ECJ eventually declared that EC law was supreme. And this is really a natural development for that. And I find this alternative vision of the ECJ quite fascinating because it raises two questions. First of all, it's so amazing because there's actually a lack of empirical evidence of specific texts which mentions all these principles they've just expounded, apparently declared interpretatively. This lack of actual written down text, the member states never conceived of this nature, this whole EC as was just expounded by the courts. So, is that really interpretation? Because it seems to me to be more like creation of new principles, rather than interpretation. But if it's so, how do you justify that? Now, to add a twist, the Court of Appeal apparently justifies by saying that they were interpreting apparently really clear